Welcome, I'm Russell Alexander. I've been a lawyer with the team here at Russell Alexander for over 20 years. We help families who are going through separation and divorce. Without further ado, let's get into today's topic. Maximal contact principle replaced by meaningful and consistent relationship with both parents. In a recent Ontario court, the Ontario court explained the conceptual shift that has taken place under recent changes to federal and provincial family legislation. Among many others, one of the noteworthy changes is that when it comes to the court making a parenting order, there's no longer focus on maximal contact principle. In a recent case, the parents had been in a 5-year common law relationship. The mother asked for their child to live primarily with her, partly out of concern over the father's substance abuse, which he denied. She asked that he should get only specified parenting time, conditional on him complying with certain orders around his drug and alcohol use, including testing. In this context, the court summarized law around parenting orders under the newly amended Ontario and federal family legislation. It began by noting that in March 1st, 2021, the parenting provisions contained in the Children's Law Reform Act came into force, and there are corresponding recent changes to the Divorce Act. If you're enjoying this video and find it helpful, you can give it a thumbs up, or please leave your comment below. Next, the court noted its power to make parenting orders is broad and purposeful, and that it could allocate parenting time and decision-making authority between parents, impose a schedule, provide the means of communication to be used by the parents, and make any other orders that it considered appropriate to secure the best interests of the child. Then, after cataloging almost a dozen specific elements listed in the Children's Law Reform Act as being components of the circumstances of the child, and noting that it must stay laser focused on the child's best interest, the court made a point to say this: maximal contact, there is no presumption in favor of joint parenting, and the term maximal contact is no longer found in the Children's Law Reform Act. The legislation states, in allocating parenting time, the court shall give effect to the principle that the child should have as much time with each spouse as is consistent with the best interests of the child. Clearly, the idea of a presumption in favor of one type of parenting order is not for the court's unrelenting focus on the child's best interest is where the court should focus. The most one can say is, all things being equal, the child deserves to have a meaningful and consistent relationship with both their parents. With this in mind, the court reviewed the parents' particular circumstances, including the fact that the child had resided with the mother for the entirety of her life and was very young and vulnerable. It also scrutinized both parents' plan for the child, noting that the mother was demonstrably in line with the child's best interests. Conversely, the court questioned the father's credibility around his substance abuse and also his judgment. On one occasion, he had withheld the child from the mother, which could have put the child at risk if he was indeed using drugs or alcohol. This, the court said, displayed a lack of respect to the mother and the court and was not to be tolerated. In the end, the court granted the mother's request for a temporary order in various terms, giving the father parenting time only in accord with a set schedule. To learn more about this case, you can read the full article linked in the description below. Please give us your thoughts and comments below. Once again, if you've found this video helpful, please give it a thumbs up to let us know. You can subscribe to our channel and hit the bell icon to get notification every time we upload a new video. Thank you for watching.